We're going to be switching gears and switching over to our West Plains office. Our bandwidth is such that when we're seeing them on the screen, it's a little bit slow bandwidth, but it'll all be kosher as soon as we switch over to the PowerPoint. Everything will work just fine. So at this point, I'll switch and turn everything over to our attorney in West Plains, Sarah Bernard. Go ahead, Sarah.
Thank you, Deanna. Can you hear me all right?
Yes, we hear you just fine.
Okay. Today it is my pleasure to introduce the Honorable David P. Evans. Judge Evans graduated from West Plains High School. Later, he graduated from Southern Methodist University, summa cum laude, with degrees in business administration, political science, with a minor in economics. In 1985, he graduated from Southern Methodist University Law School with honors. While there, he served as chief counsel for the SMU Legal Clinic. He was admitted to the Missouri Bar in 1985 and was awarded the Missouri Bar Pro Bono Award in 1991, an award that Legal Services nominated him for. He practiced in a private law firm for 6 years until he was elected Associate Circuit Judge of Howell County, Missouri. He served in that capacity for 15 years until 2006, when he was elected as the presiding circuit judge of the 37th Judicial Circuit, which includes Carter, Howell, Oregon, and Shannon counties in Missouri. Recently, Judge Evans was appointed by the Missouri Supreme Court to serve on the Civil Rules Committee and the Finance Commission. Judge David Evans.
Thanks, Sarah. I remember harking back to law school days. She was talking about that, how excited I was to have both tax planning and estate planning on the same day. So I'm sure everybody here is on the edge of their seats to talk about ethics this afternoon. Have a PowerPoint, and Chris Fisher, one of the local attorneys who knows me, says, we've already got that, Judge. It would be better if you just said, are there any questions, and sit down. So I'm thinking about that, but they said I need to take at least 50 minutes, so I'll try to do that this afternoon. I was hoping you wouldn't have it, so at least there would be something exciting for you to think about and look at as we went along, but just don't look at it until we get to the slides, maybe, and I'll be okay. Had the help of Justice Zell Fisher. Zell is a Supreme Court judge, appointed a few years ago. He was, before that, an associate judge and trial attorney in northern Missouri, and a local law clerk, Nikki Labarde, assisted him in that. So a lot of this is his stuff, so hopefully that'll give a little more oomph to my presentation, knowing this comes from the Supreme Court. About half of it is original stuff, half of it he let me borrow from him. So we'll go on to the PowerPoint and probably cut back and forth a little bit as we go along. Whoop, now you're in the wrong one. His presentation was other lessons learned from classic country music, but one of my hobbies or pastimes is to get away from things, is to watch movies and classic cinema. But to me, and I've always felt this way and still do, and I always, when I do jury trials like I'm going to start tomorrow, I always talk to the jury about their civic responsibilities and duties, and how our system of courts and government date all the way back in jury trials to the Magna Carta. Our court system, of course, and the other branches of government are designed to balance each other out. And I'm going to mainly talk in my short time here this afternoon to the younger attorneys about ethics and how to build a career and to stay competent and sane during that career. But it doesn't hurt to remember these things for all of us. And as I remind my juries when I do those trials, but part of what you do, particularly in legal aid, and I can say one of my, still to this day, my greatest honor maybe in my professional career is receiving that pro bono award from the state bar. and that was from I did a lot of work as a young trial attorney with legal aid out of Springfield and helping those clients. And what you do is help balance that power to individuals. And from their point of view, what you do is the most important thing there is, the most important thing in their life. Whether it's as a guardian ad litem representing a child that has no other voice, whether it's representing the spouse that may be abused at home and literally has no voice there, and I've seen that many times before, whether it's representing a defendant in a criminal case where they have the power of the state against them and there may have been an injustice in their charge or how they were prosecuted. But from that point of view, what we do, what particularly you do, and the personal satisfaction you can gain for doing a good job and helping them, even if it's not the perfect result that they hope themselves, but getting that good result for them and making their voice known and heard is a great thing. And we still have, and I still firmly believe, one of the best systems of justice anywhere that ever existed in the world. And one thing, particularly in these smaller communities, and we see it more pointedly maybe from my position from the bench, but even the attorneys that live in the smaller areas, and to some extent Springfield, but you're an attorney not just in the courtroom where it's most important, but at your office, at the ball game at night, everything you do, people will recognize you as a member of the legal bar, a member of the profession. So your responsibility to be a professional goes beyond just the courtroom. It goes beyond everything you do. And again, as a judge, it's even more conscious of that fact. If we could go to the next slide. And one of my favorite movies, and favorite all-time classic lines, remember, with great power comes great responsibility. And again, we don't think of that, and really on the bench, I don't think of myself as having a lot of authority or power, but in reality, I may. But we're bound by the rules, we're bound by the laws like everybody else. But from the client's perspective, what you do for them, that's great authority, that's great responsibility that you owe to them, and also to the bar, to our profession, and to the system of justice itself. I was hoping we'd be able to have more interaction. I was going to have a little contest with bonus points of who could identify the movie, the character, and the actor. I don't know if we can do that by maybe offices, who can get the best at the end of this, who can identify who these people are. So keep that in mind. We may try to come back to that later. It's not a real good system for jumping back and forth, though, in a limited period of time. If we could go to the next slide. This is this comes straight out of the rules. One of the fundamental responsibilities, and sometimes young attorneys think that representing their client means only doing what the client asks them to do. But being a good attorney, being a professional, requires us to go beyond that. We have to maintain our independence, but also give good, solid advice to the client, what they can expect in the trial, what may work, what may not. Attorney's job, and I'll reiterate this throughout, is to think about the laws and issues in the case, to plan their evidence accordingly, and to put on the most important evidence for the judge. And that's what judges are hoping for, more than the hype and the arguing back and forth that often you'll see in legal aid type cases, domestic cases, a lot of legal aid cases involved, a lot of cases I did as a legal aid attorney. A judge is looking for just the facts. I should have had that screen up there. But more important than anything, bottom line, what does the judge need to make a good decision for your client in the case? Skip to the next slide, and following up, this is Justice Fisher's slide. Again, the same thing, another set of rules about loyalty to the client. Also means being independent and professional, giving good, candid advice in the client's best interest. Sometimes as a lawyer, to be a good trial attorney, and it's not one of my strongest suits, but a lot of attorneys are very strong personalities, type A personalities, good communicators, very confident in their abilities, and you need that often in a courtroom to not be shy or bashful about presenting a forceful argument to the court. But on the other hand, sometimes, and I've seen this over and over, the best attorneys that can shoot from the hip, that can cross-examine a witness so effectively are not always the best attorneys in talking to their clients and communicating with them about the case and strategizing and planning how do I really present this case in the most effective way. So often the very best skilled person standing in the courtroom will not be the best prepared. And personally, as a legal aid attorney who didn't always jump up and yell and scream, sometimes as you see in court, but I always tried to be better prepared than the other side. And judges, I can assure you, particularly judges, we've got Judge Ray Lee Caskey, who was an associate judge for many years, and a circuit judge down here is with us, but you decide your case on the facts that you're presented. If I have contentious attorneys, my favorite thing is just to get up and walk out and let them continue to argue if they can't get it under control, or daydream. If attorneys want to argue more than they want to present facts, I'll start thinking about what I'm going to do tonight more than listening to them chatter against each other. Because I'm, again, looking for what's important to that client, how good a parent they are, is this person, what facts support his guilt or innocence, or personal injuries or negligence in the case as it may be. So let's go on to the next slide. So the ability to really sit down and talk to your client, and I've seen this with doctors as well. I think there are statistics for this, but I've seen it from personal experience. You're more likely to be sued as a doctor or a professional if you have a bad bedside manner. If you talk to your clients, even if the result is not what you expected, even if you might have made a mistake, if you visit with them, talk about it, talk how you're going to correct that or other avenues you can take, explain ahead of time what they can expect, you're far, far less likely as an attorney to see ever a bar complaint, to ever see a case against you in court. And just like anybody, I hate to see cases, malpractice cases against attorneys. They do happen. And, in the back of my mind, I wonder if the attorney had taken the time to, even if they're the best trial attorney, if they'd taken the time to sit down with their client and give a little more detailed advice, they wouldn't be in that position to begin with. If you go to the next slide. And another thing you learn, and attorneys know but don't always practice, you have to cover your donkey, cover your backside, but that's not in just a selfish way. What you're doing is giving the client the pertinent facts, the pertinent law they can expect, and potential results they can expect in a given case. And again, that's part of putting it in writing. They may have different expectations. They may walk away from court. They may walk away from your office thinking something different was said than the judge may have said that you may have told them. But reiterating that in writing is certainly, I think, the best way, and always is and always will be, of focusing your client on really what's important in their given case. Let's go on to the next one. This is a justice slide again. Again, part of being an attorney, and I remember feeling this same way as a young trial attorney and sometimes competing against lawyers who I suspected were not telling the truth or were bending the rules in some way to gain a tactical advantage or just outright making things up. And I still suspect that and think that of some attorneys that come in front of me. But that's always a slippery slope. And once you start down that road, as I say, you're going to the dark side. Without doubt, without question, in my mind, both from this side of the bench and as an attorney, again, that trial preparation, simple rules to follow, like never calling a witness, subpoenaing a witness, bringing them into court unless you talk to them, know what they're going to say, never cross-examine a witness until you have a good indication of what to expect from that cross-examination. It doesn't mean you have to depose everybody, but calling them on the phone, obtaining discovery about potential statements of witnesses is a way to, again, to gain a tactical advantage without resorting to degrading the system and degrading yourself by trying to falsify evidence or fudge a little bit here, and the temptation is there for everybody, particularly, again, since we're in a competitive business. Let's go on to next. One thing I see as a judge, maybe more than any other, is attempts at ex parte communication. And I'm pretty well stay in my office. I intentionally don't try to socialize much with my brethren on the bar because, again, you go out at night, you may have dinner with Mr. Caskey. If I have him in court the next day, I guarantee you the parties know about my dinner date with Mr. Caskey and his wife, and they'll think something suspicious is going on in my case. So I try to isolate myself. It's kind of a lonely job in that way. But as far as where I see it more is where attorneys will write a letter to the court and set out a whole bunch of facts and try to excommunicate, ex parte communication with me in that fashion. It doesn't do really any good to try to do that. I really just generally ignore that or just glance at it briefly. Sometimes I've even had attorneys I suspect have their clients send letters to me or to the file through the back door, try to get information. And again, most judges were required to disclose that, and we don't take it as evidence. Again, I'll glance at it, see what it is, and then communicate with the attorneys. I can't consider that information. The more professional thing is always, there are legal means for disclosing new facts or evidence, motions for new trial, post-trial suggestions, pretrial suggestions or argument, pretrial motions, rather than trying to get that in through the back door through some sort of letter or communication either by you or your client to the file. Just want to go on. And another Justice Fisher slide, but again, what judges are looking for and what clients are looking for, and this is the number one thing I see, particularly in domestic cases. Attorneys don't always think through the issues and prepare their case thinking about what they need to prove in court. It's really easy to get swayed by a client that has a lot of different motives, and it's difficult for the client to see the big picture, and they're motivated by a lot of little things, but to concentrate instead on what's important for the fact finder in your case. And a lot of attorneys will just show up in court, particularly, I've seen some of the worst offenders, again, are the most talented. that can speak from the cuff so convincingly that I guess they think they don't have to prepare as much as everybody else, but don't put on the evidence you need to make a decision. Particularly in domestic cases, you have to be, the judge has to be so detailed in their fact findings today. So you really need to go into detail about the evidence you're putting on in court. And next, this is an easy one, Jack the Giant Slayer. I'm fully convinced of this. You can win your case on the facts more than you can on overly aggressive trial presentation. Careful and considerate trial preparation, again, is the key, as far as I'm concerned, to doing well in virtually any judge's courtroom. And let's move on. I kind of divided this into pre and trial. Good attorneys, from my perspective, one of the most important things, I put second most important thing, they need to know, at least have some information about, particularly in domestic cases, but any type of case, is the audience you're dealing with. Harking back again to college and what we learned in Speech 101, you've got to know first who your audience is and how to communicate with that audience. Let's move on to the next slide. Whether it's, we've got four different types of judges here, but knowing that judge, knowing what local rules or procedures, the quirks that each of them or she may follow, whether your client may want to, as allowed in Missouri, to disqualify a particular judge in a case, if there are any local court rules, at least you ought to glance at those if you're dealing in a foreign jurisdiction that you need to be following. A domestic case, different judges have different types of forms they rely on most heavily. I certainly did. And I always wanted forms, property forms and child support forms that are very clear and concise to give me a good summary. And even better if attorneys would exchange those forms and build on each other's property lists so that the judge knows he's getting inaccurate information. But trial attorneys, I think it's essential, second most important thing as far as I'm concerned to being a professional trial attorney is to know who you're dealing with. And same thing with juries. A lot of attorneys will bring in a local person. I've had Mr. Caskey assisting in picking juries in different locations. With an out-of-town attorney, but never forget the importance of that in a case. Let's go on. This is partially Judge Fisher and mine. He went into great detail in his about specific courtroom behavior, but it really all boils down to common sense stuff. While in court, you need to act like the professional that each of us are. One of the biggest pet peeves of mine, and you see that a lot in rural jurisdictions, we have law days where there's 50 different types of matters going on. The attorneys are trying to deal with the prosecutors, they're trying to discuss motions, and it's controlled, often controlled chaos in those types of cases. And as I get older, not only is that aggravating to me personally, but again, what is a courtroom for? You're there representing in a very serious way your client. And to them, this is the most serious, important thing in their lives at that given time. And to see attorneys joking with each other, carrying on, I think degrades that a little bit. And from your client's perspective, I think it's better to act like the consummate professional that each of us are, to respect the courtroom. You don't have to respect the judge, I wouldn't ask for that, but respect the courtroom and the justice system that we work for. And I would always encourage you to don't speak with other attorneys, don't talk out of turn, don't over-talk, or try to talk down particularly the judge, but also the fellow attorney. That's not professional, in my opinion. The clients don't think that's professional. They think it's rude, just like it would be rude if you tried to do that at a funeral or tried to do that with your preacher at church. Certainly it's no different than that. And that's one of the hardest things for attorneys, particularly in rural areas, to grasp is if you got to talk, go outside. Maybe we've allowed that too much in the rural areas, but again, that's a pet peeve of mine. And the older I get, the harder it is for me to hear when I've got several groups of attorneys trying to do business in the courtroom, but they're not doing business with me, they're doing it with each other. But the rest of this stuff is really common sense stuff. But every one of these on the screen I've seen attorneys not do these things. I've seen attorneys play games, and not know how to address the court, not dress professionally, chew gum. I think that's, or skull. I've seen both of those. And to me, that's really reflects badly on us as a profession. Again, that's a speech 101 thing. You don't chew gum and try to be serious and make a formal presentation. But nevertheless, you'll see attorneys still do that from time to time. And this is an area where I'm not that way. I'll just note that in my head and typically won't address down an attorney in open court. I really refrain from doing that. Makes them look unprofessional, and there shouldn't be any need to do that. But some judges enjoy harping on attorneys about a lot of these things. And if you can't be courteous or want to chew gum or talk, or your client, I'll never forget when a judge really chewed me down when my client had his shirt tail untucked. But I didn't know that about the judge, but I knew that after that point. And I always tried to do a better job of watching what my client wears. Let's move on. This is a Judge Fisher slide in 3 parts. I'm sure you can recognize that movie. And he had a whole series of slides, a long presentation on what to wear. And it came out about a year ago also in Lawyers Weekly, where they did the survey about men and women and what we should or shouldn't wear. But again, it's largely common sense stuff, what you would wear in any formal occasion or semi-formal occasion. You're not there to draw attention to yourself. Let's go on. There's like 3 parts on this slide. He was a little fancier than, it's not your time to stand out in court or to emphasize. Just leave it on that. It's fine, what you wear. Another thing that doesn't help, particularly in front of juries. Go ahead and we'll jump on. Particularly in front of juries. Being overly aggressive with witnesses. I've seen attorneys, I think, really lose their client's case by doing that. Juries are particularly sensitive about that. They expect it with witnesses that are paid to be professionals. You know, law enforcement, you got to be able to roll with the punches if you're a law enforcement officer. Paid witnesses, paid professionals, you kind of have to expect that when you're being paid to testify. Kids, you never want to make a kid cry in court. That's pretty common sense stuff. But sometimes it's hard, literally hard, for some attorneys not to be overly aggressive. But as a general rule, with judges, it's not going to help you. And with juries, it can hurt you. Let's move on. Another Judge Fisher slide. Again, very, very basic stuff. And I'm not going to reiterate this too much. But emphasizing, again, the common sense of just civil behavior in general. Be on time, don't eat in the court, don't chew gum. Address the judge as Your Honor. May it please the court. And another slide we'll get on to in a minute. Maybe, if we're sitting around talking in the table, there's in a conference room setting, we've outgrown that, or there's no need to be that formal. But again, what we represent is something far more important than that. We represent a system where clients expect it to be serious. Clients expect it to be formal. Clients are expecting something to happen in their lives in this proceeding. And they see it extremely serious, regardless of how we sometimes think about court or think about what we do. From their perspective, again, it is the most important thing in the world. But again, emphasizing the often overlooked, as far as judges are concerned, need to be the best prepared person in the courtroom. And that doesn't mean going on and on. Let's go to the next slide. And I was hoping to be able to, again, go over these slides. Anybody recognize that? Of course, that's, I think, Chicago, Razzle Dazzle Me. That always sticks in my head. That was a neat scene from that movie. And it looks good on TV, but it usually doesn't work from our perspective. Being too aggressive, offering repetitive evidence, 2 or 3 times is enough. Once you get up to 5, 6, 7, 8 times, you're not gaining, you're going backwards in your presentation. Another thing that some attorneys can't get out of their head is repeatedly making objections. I don't know if they think that's impressive to their clients, and maybe it is, but it certainly isn't impressive to the bench, to the judge, when most of those objections are, who really cares? Objecting to a leading question when it's a foundation. Or if it's hearsay and you're just, again, laying foundation or something that's pretty trivial in the case. I would always urge you to hold your objections to stuff that really makes a difference, that really shouldn't be coming into court, that rather than stuff that it's going to get in anyhow if they just rephrase the question a little bit. And it's not helping your client, it's just delaying things and maybe angering the judge a little bit at your tenacity and trying to show off in court about making so many objections. Next slide. Another famous lawyer movie, and this is Judge Fisher's, that may be in 3-part 2. Go ahead and put all parts, there we go. Again, common sense stuff, but it happens. And with some clients, you need to, suggest to them in advance they don't curse, use obscene language. Again, I've heard it before, I'll hear it again. It's not going to alarm me too much. Again, some judges, that's one of their pet peeves in court, and you'll get a tongue lashing if that ever occurs. But the most appropriate way to deal with anybody, your spouse, your client, the court, is to be honest. If there are weaknesses in your case, it doesn't hurt to concede points. Actually, that gives you brownie points with the judge. If you've made a mistake, as far as I'm concerned, I'm there to help things along. And sometimes that means helping attorneys get out of problems. I'm not taking sides in a case. But if I can make an order that will solve a problem that, I'll try to do that. If it's not prejudicing the other party by doing so. And common sense stuff, don't yell over the judge or opposing counsel. For one thing, we can't pick it up on our records. If you try to talk over somebody else, the court reporter or the transcription tape, it's very difficult to transcribe 2 things simultaneously. The digital stuff has multiple channels, and our court reporters have several different sources of information, but still, if you're talking in a loud voice over each other, it just blends together. So from that perspective, don't do it. But again, you're not gaining any brownie points with a judge or jury. Let's move on. What's next? I'm going to try to wrap this up early since you've already got the slides. Again, this is a Judge Fisher slide, again emphasizing the core things that are important in court. Be courteous, respect the system. You don't have to respect me or the judge. Respect the system for what it represents. And part of that is going the official way, may it please the court, Your Honor, addressing the witnesses, the judge, in a very formal fashion. Limit your arguments to being succinct, concise. Think about your case beforehand, plan it accordingly. 9 times out of 10, you'll kill the other giant if you're better prepared on the facts than they are, even though they are better skilled or more experienced trial attorney than you may be. Let's go on. Probably, in my mind, the most important, well, I know, the most important piece of advice I got as a young attorney from the person I went to work for out of law school was this very point. What we do can be very difficult. Trial attorneys sometimes get a lot of criticism in the media, and jokes are made about trial attorneys. But it's one of the most difficult jobs to do well because you're dealing with a lot of people's problems. And one of the great things about our system is you can deal with very serious, difficult issues that people face in everyday life without getting out the gun and shooting each other, or without the system itself imploding. As I said, what he told me, you've got to learn to hang up your hat at the end of the day. That does not mean that you don't have empathy and sympathy for your client and their problems. But you've got to learn to separate those problems from your own life. And I've seen several attorneys get in very serious trouble when they've not been able to do that. Because life happens. There'll be problems you'll have in your life. It may be at home, it may be a death in your family, it may be an accident or injury to yourself, or an illness that you have, or to one of your kids or your spouse or family, whatever. But difficult things occur. And if you're consumed by your client problems, and I've seen it time and time again, and you internalize those as your own, that's the camel that broke, the straw that broke the camel's back. You find it very difficult then to deal with your own reality and the own problems that will inevitably face every one of you. So being able to professionally separate and distance yourself doesn't mean you can't be the most compassionate attorney on the face of the planet, but when you go home at night, you can set those problems aside and to your hobbies, to your interests, to your family, to whatever. You have that release from the life and the very difficult job of being a trial attorney. Because each of you know, clients think about their cases 24 hours a day. When something is pending in court, it literally can consume their life and their emotions. But we can't allow that to be all-consuming in our life, or you won't be able to be an effective attorney for very long. And the next slide, I may have rushed through this too quick since you have the slides. Many times attorneys get into trouble, and I've seen some local attorneys in this area get disbarred when they have allowed these problems to build, not only with their clients, but their personal lives, where they simply are not able to function effectively any longer. Make silly mistakes, take shortcuts that they shouldn't take, go a path that nobody would have dreamed of, that they would fall, but it just got too much. The bar does have, and I would encourage anybody to make use of that, if you feel those pressures building, and inevitably it's going to happen in your life because life happens, take advantage of some of these services that our Bar Association wisely has, and get some help before it's too late. Again, I've seen some extremely good and competent and caring people lose their license, get in trouble with the bar, get in trouble with their clients because they couldn't deal with the problems that built and they allowed to internalize before it became too late. Next. You've already got it. I didn't know you were going to have a copy of it. But again, I thank Justice Fisher and Nikki for a large part of what you saw today. But I'm going to, maybe we can get out of here early, maybe open it up early. I don't have a clock on me to know what time it is. Do we have, folks, any questions? Even locally here? All right, it's been a pleasure.